Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about the air of reality test. Cases that should have gone to the Supreme Court of Canada, but didn't. In criminal law, if you are advancing an affirmative defense, in order to have that defense put before the jury for consideration, the defense has to have what is known as an air of reality to it. In Mr. Cameron Kinnavanthon's case, he argued that the air of reality test had been met in relation to his charge of discharging a firearm because he had done so by accident. The Crown conceded that there was an air of reality, but the judge nevertheless intervened and prevented him from putting his defense before the jury. And while judges have an ability inherently to control the process in the courtrooms, there is a question that arises from a judge neglecting to allow the defense to be put before the jury when both the defense are saying the air of reality has been made out, as is the Crown. If both the defense and Crown agree that a defense has been made out sufficiently for the jury to consider it, should a trial judge have sufficient power to intervene and nevertheless prevent the jury from hearing that defense? If it's enough to persuade a prosecutor, who's the one representing the state in relation to the criminal charges, and enough that defense was able to ethically advance the defense in the first place, should it not be left to the jury as the trier of fact to determine whether or not that defense exists? How much intervention should a trial judge actually have in what defenses are put before the jury where a court is being asked to consider them by both parties? This case raises really important issues about the interventionist role that trial judges play in jury trials and how a trial judge's role may potentially water down the import of a jury trial and the accused's decision to select a trial by jury. If you have the right to trial by jury, shouldn't you ultimately have the jury be the ones deciding your case? But if a trial judge intervenes, even where the parties are in agreement, doesn't that eliminate really the right to trial by jury and the right to have your peers decide whether or not you are guilty of the offense or whether or not you have a defense? It's unfortunate that this case didn't get leave to the Supreme Court of Canada because it does raise these important questions about a constitutionally protected right in Canada and an important aspect of our legal system. Hopefully another case comes to the Supreme Court of Canada where the court can determine whether or not and the extent to which a trial judge can intervene when a defense is being advanced by consent. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.